Hello and welcome to Legalese. I'm Ernie Hyde, your host, and Legalese is brought to you by the Northern Middlesex Bar Association on a monthly basis. This particular show, this episode, is going to be on basics of estate planning, and I have with me Nancy Catalini Chew, who many of you have seen before if you watch this show. Anytime we get involved with estate planning, Nancy's close by. Thank the Lord. And thanks for coming on.
Thank you.
Before we get going, I'd like to say hi to a lot of stations that carry us that we don't think about very often, only because they're not in the jurisdiction of the Air District Court, which are about 11 towns in north central Massachusetts. But we do have stations in Salem, Mass, Revere, the Lower Cape, which consists of Eastham, Brewster, Truro, Wellfleet, New Orleans, and Sterling, Lancaster, Lunenburg, Norfolk, and Franklin. And then we have one in Troy, Alabama, and one in Contra Costa, California. So
Wow.
Much of this will apply to all of you, believe it or not. And even though we're talking about Massachusetts law in general, when we speak, many of your states that do watch us will also have similar laws, if not exactly the same. So let's get going. The first thing we're going to talk about is wills.
Okay.
And so in Massachusetts now, since I said we are going to talk generally about the rest of the country as well, we now have a different set of code that we go by since last year.
Correct. That would be the Massachusetts Uniform Probate Code.
Which is similar to many other states.
And that was the initiative behind it, was to try to make us more in line instead of being an island unto ourselves.
Right. So instead of doing it the Massachusetts way necessarily, we do it a general way.
Right.
Okay. And so one of the things that we've changed in that code is we used to refer to executors and executrixes and administrators, administratrixes, and so on and so forth.
Correct.
And now it is one phrase, personal representative.
Right.
Any difference in any of that other than the words?
No, they used to make a distinction with whether you left a will or not, and that determined the nomenclature, and now
Right.
it's just a generic term, which nobody knows what it means, but there you have it.
Everybody gets it.
It comes with used to be called executor after it.
Okay. And there is now the ability in a will, though, for a personal representative to appoint a subsequent personal representative.
Which is sort of an interesting little opportunity, if you want to look at it that way. I consider it something to be very careful about, because you might end up with a completely unintended fiduciary. But technically, you can leave your personal representative with the ability to appoint their own successor rather than you appointing one.
So that means you don't necessarily know who that's going to be.
Correct.
Or how well they, in your mind, might manage your estate.
Correct.
Right.
But you can also preclude that if you
From
want
happening.
to. From happening. So
Well, you
don't have
preclude
to
it
do
by
that.
not mentioning it, right?
Yes.
I mean, you have to mention it in order to let it happen.
Right.
So I think the trend is similar to yours,
Yes,
your way of thinking.
to
in
not
that
do that.
It's not a good idea necessarily.
Correct.
although it's
Unless you really
available
don't
to-
have anybody to pick. But that's very seldom.
Okay, the other thing that we've come across, in the past, we used to say an awful lot in wills, I give, bequeath, and devise, whatever I'm giving.
Yes.
Now we only have to concern ourselves with
Devising.
devising. And devising was a term that we used to use in relationship to real estate,
Yep.
but now it's anything.
Correct, because they've sort of gone away from the distinction between your personal property or your tangible items and your real estate, and it's all kind of lumped together universally as my property, my estate, whatever I might leave.
And this is these word changes have confused clients. Frankly, clients that have been with us for many years come in, they say, I want to change my will, and they start talking about it, executors and
Right.
so on and so forth. And we're talking a whole different language, and they're starting to think,
What are
you
you
lose
talking
it?
about? Right.
Where
what?
No, we haven't lost it. We just found it, as a
Yeah.
matter of fact. So,
Yeah.
Just pay attention to the nomenclatures now and
Exactly.
the titles.
Exactly. The end
Okay.
result should not be any different. It's just the titles. Yep.
One of the things in wills that when people say, should I have a will? My typical answer to that is yes, but let's talk about it, because sometimes the answer is really no. But one of the reasons for having a will is to appoint a guardian for your children if your children are minors. You want to talk
Correct.
about that a little bit?
Correct. Any minor child under the age of 18, which is the age of majority in Massachusetts, you have the opportunity to appoint a guardian for that person. Frequently what I find is even with married couples, they assume the surviving parent is the legal guardian, and actually you're not the legal guardian unless the court appoints you as one. So we always de facto put that in as the default, because certainly you don't want to skip the other parent, but it's usually a surprise when they see that in there. And then you have the opportunity to name your choice of successors, and people say, well, I have parents or siblings, so why is that important? Well, the reason it's important, because if you don't do that, then you run the risk of whomever can get to the court and file papers fastest and can't be proven unfit becoming appointed rather than your choice.
They win. Yep. The other thing that we do in trust, other than the obvious, I guess is what I'm saying, and the obvious maybe isn't so obvious, so I should say it, is to give your assets away and to some extent pay your debts to some extent.
Yep.
And also talk about maybe your burial plans and what you would like done and so on and so forth. Kind of obvious types of things that you would do in a will.
Yep.
One of them, though, is a testamentary trust. You want to talk about that a little bit?
A testamentary trust is something that appears in your will, and I usually like to explain it to my math-minded clients as an if-then statement. So if my minor child survives me and is under the age that I've chosen for them to manage their own money, then I want this trust to rise up and protect their funds. If my disabled family member survives me, then I don't want their benefits compromised by what I might leave them. So then this trust rises up and takes care of them. If I have an ill spouse at the time of my death and they might be receiving nursing home benefits or the like, then I want this trust to rise up and protect it. So it's those kinds of things we don't necessarily know will occur, but we're concerned they might occur, and the potential devastation to the funds I'm leaving behind. So in those sets of circumstances, that trust can be drafted in there to rise up and protect those funds.
At the right time.
At the right time,
At the right
after
time.
your death.
Okay. Good. The ability to exclude beneficiaries, which is something that comes up a lot more than you might think,
Yeah.
or clients might think. Can you exclude anyone?
Well, you can write it in there, what your intention might be. The only relationship that is difficult to exclude entirely is a spouse, because even if you exclude them for whatever reason, and it might be a reason you've discussed with the spouse and actually makes sense to both of you, that spouse will still have the opportunity upon your death to what they call elect a share. So you can't preclude them from just saying, even though I'm left out, I want X percentage, but you can still write it in there, and if they don't overtly follow that, then they will be excluded. Other than the spouse, you can eliminate other people, although you have to be warned that, of course, they'll have the opportunity to object. If they are technically your next of kin, your children, say you have 3 children, you want to leave one out for whatever reason, that third child will still be notified about your will and have the opportunity to object to it. So you need to be aware that it's not going to go unnoticed.
Won't be a secret.
Right.
Right. Okay. Anything else you want to add to wills before we move on?
That pretty much covers it, I
Okay,
think.
Good. The next thing we want to talk about is trust, because this is a often misunderstood phenomenon
Yep.
that lawyers made up somewhere along the line.
Yep.
Great job. But anyway,
Not us, though, so it doesn't matter.
no, not us lawyers, but some other lawyers made up. And so what exactly is a trust?
The way I explain it to clients, it's like writing your own beneficiary designation. So instead of putting your assets with Prudential or John Hancock or some other entity and relying on their form that might give you an inch and a half to write what you wish, you're saying, that's great and well and good, but I want to write something more extensive, or I want to encompass all of my assets, not just this amount that I have with your company. So you create a document from scratch that dictates who you want in control of the money instead of a company, dictates what you want to happen upon your death, and sets forth the details in much more depth than you're allowed to when you put a specific asset. So you're saying, rather than going asset by asset, I'm going to lump it all together into a trust. The most basic outcome of a trust is that you avoid probate. So rather than having to have my assets go through the court system so that the court will show by validating the will where my assets go upon my death, I put them into this private document that I've created, and the court stays out of that process. Mm-hmm. You can add lots of bells and whistles to that. Again, as we sort of mentioned before, if someone is disabled, if you're concerned about their financial responsibility, if you're concerned about them becoming divorced, sued, bankrupt, you can add a lot of layers to it. You can deal with tax problems either during your lifetime or at death. You can add in protections for nursing home. So there's lots of pieces and aspects to it, but the general concept is I'm pooling my chosen assets into this vehicle, and I'm electing the different shades of that I want to put into it.
Okay, and so we're going to have an entire show dedicated to trust next month, and I think it's important to do that because there are so many different types of trust and so much confusion going on about what they are
and people
how much
read an
I need
article,
them,
and people read a little piece of it, or they go to Bridge Club and somebody has this type of trust and they think that's what they have, and they're like a box of crayons.
Right.
There's lots of different flavors. You can take a couple of crayons and combine them even.
Yeah.
So you need to be very careful when you do that you know what colors you're trying to get to.
My first hint that there's going to be problems in the morning about trust is when I hear an ad on the radio on the way home that says you absolutely need to have an irrevocable trust.
Yes. And sometimes people come in and ask you that.
Starts ringing.
Exactly.
And they want an irrevocable trust, and they have no clue why they want that.
Right. And I have to say, why do you think you want one? Well, Mary down the street having one is not a necessarily reason to have one. You might end up with a reason to have some variation of a trust, but there needs to be an articulated rationale for that.
Yeah. Many times when you explain it, they don't want it. But
right.
At any rate.
Right.
Okay. It's an independent entity. I mean, it survives as itself. It's not dependent on anything else, and as you say, it doesn't go through probate, which is a big issue in many people's minds.
Yes, usually a goal. Yep.
It does deal, and it can have some effect on taxable income and taxable estate taxes at the end, depending on when it's done and so on and so forth. Right? Okay. Now the responsibilities of the trustee, and there are three people, the way I look at a trust, there are three people, three positions.
Right.
I don't want to say people because they could all be the same almost.
That's true.
The settler, the person who started this whole mess.
Yep.
The trustee, who is the legal owner of whatever you give them to manage.
Right, they're the manager.
And the beneficiary.
Correct.
Okay, who have a beneficial interest in the trust. So there are three entities interested in this document.
Right.
Okay. So as a fiduciary, what is the responsibilities of the trustee to everyone else?
Well, it's interesting because that answer somewhat depends on whether the trustee is also a beneficiary or the beneficiary or the settler who created it. And the way I try to explain it to clients is, if you're managing your own money, so you've created a trust for yourself while you're alive, you're going to have a lot more freedom with how you invest and use that money than me managing your money for you. I cannot invest in pig farms in Idaho because that would not seem to be responsible for you. So my obligation to you, if I'm the trustee and you're the beneficiary, is a whole lot different than I'm managing my own money for me. I can invest in the worst thing in the world. That's sort of the very simple explanation. when you're trying to provide a more sophisticated or legal explanation, we have to point people towards the Prudent Investor Act and a lot of the newer legislation that's come out that provides a bit more teeth and explanation. What are your obligations to the beneficiaries? What are your obligations for accounting for what's in the trust, reporting what's in the trust, getting the approval of the beneficiaries of the trust? How far into the beneficiary line do you have to go? Is it just who's getting a check right now? Is it their children, their grandchildren? Obviously, you should probably not be managing a trust without at least having reviewed your obligations with an attorney and a CPA. So if you ever are fortunate or unfortunate enough to be named as a trustee, that should be your first visit. What are my parameters? What are my obligations? And then what are my discretionary responsibilities and abilities?
And a lot of people don't do that until it's too late.
No, until somebody is upset with them.
Right. And getting sued.
Yeah.
The difference between revocable and irrevocable.
Largely, it's sort of the obvious. If I can revoke it, then it's considered an extension of me. It normally carries my social security number. I amend it. I have access to the principal. It's usually something one creates for oneself, normally. Irrevocable is normally when we're trying to protect whatever we're putting into it from either our assets, our creditors, our future concerns. So it might be to protect it from the nursing home. It might be to protect that money from our taxes now or in the future. But it's normally because we're trying to sort of separate it from ourselves. The only additional exception to that is that even with a revocable trust, upon my death, it actually converts to an irrevocable, which most people don't realize. But obviously, I can no longer revoke it if I'm no longer alive. So it's just the way it has to be at that point.
Right. Revocable can also be changed, not just revoked, right?
Yes.
Okay. So
Exactly.
and anything in it can be changed
Yes.
fundamentally.
Yes.
Right?
Yep.
Okay.
It's an agreement with yourself, so you can
Right.
re-agree with yourself.
if you can do that,
Yeah, right.
many
if you have the
people can't.
facility to do that, yes.
Okay. Now, there are many types of trusts in addition to being revocable or irrevocable.
Right.
There are many types of trusts. You want to just name some of them and give a really brief explanation as to what they are.
Well, we normally start with not just the revocable versus the irrevocable, but we've already talked about the testamentary. In my last will and testament, hence the name, versus a living or inter vivos trust, which I create while I'm alive instead of waiting until I'm deceased. Within that, you might have a minor's trust, which is usually discretionary and is just being held till a certain amount of time of maturity. Might even have periodic distributions. You might have a trust to protect something from estate taxes. Those are usually created by spousal units to capture both of their tax exemptions instead of just the last surviving spouses, which will happen without trusts. We do trusts to protect the property from future long-term care costs. Property sometimes being just a house, sometimes being more than that. Special needs, supplemental needs trusts for disabled people. So that's those are some of those crayons in the box we were talking about earlier.
A lot of variations of them.
Yes.
And many of them having to do with taxes, but some having
Correct.
also
They all
to
have
do
tax
with special
ramifications, even if
situations.
that wasn't your goal.
Right.
So there should always be a discussion about what are the capital gains, income tax, and estate tax effects of any type of trust that you do, so that you know what you're walking into.
Okay. In order for a trust to actually be a trust, though, regardless of what we just said, it actually has to be funded.
Yes.
And by that,
Well, and I see a lot of this, it's empty trusts. You know, people come in and they're really proud of this book
Yeah,
of documents they
believe me,
have.
I've seen them.
Here's my book. Like, great, what's in the name of the trust? Oh, well, nothing. My bank
Nothing.
accounts are all in my name. My house is in my name.
Right,
I never
right.
did anything to it. So it's like you went to the bank and you opened an account and you never put any money into it.
Right.
Well, it's great you have it. It actually didn't accomplish any of your goals. So the back layer, once we have the legal framework, is to now actually point your assets to it. Whether that means you have to actually retitle the owner, whether that means you can get away with just changing a beneficiary so that upon your death it goes there, is something you'd have to go through asset by asset with your attorney. But you do have to do the behind the scenes work to get it to actually progress the way you want it to.
okay, good. All right, and can a trust be either oral or written?
No, it should be written under the new Uniform Trust Code.
Right. In the past, it could be oral, but you're right, under the new code, nothing should be oral.
Nothing should be oral. Not in the
Nothing.
world we live in,
Nothing.
unfortunately. Even if you could probably try and sort of get away with it, I wouldn't go there. Unless you like videotaping.
That's for
Maybe.
sure. Okay, let's move on to durable power of attorney, because I
Okay.
think it's one of those documents that a lot of people think they need, and many of them do, but they're not sure what they are for.
Yep.
I have a lot of clients say to me, so this is something so that my son can take care of things after I die, and,
Right.
and here we go. Yeah.
Yep. They don't understand the distinction between a will or a trust, which is designed
Exactly.
to deal with my post-death wishes, and a power of attorney, which is really designed to deal with my incapacity. And if I'm incapacitated, who takes care of my bills, my paperwork responsibilities, my financial requirements? Upon your death, will that job revert to the personal representative or the trustee? Yes, but while you're alive, that can be accomplished through your power of attorney. And it is, again, the financial paperwork writing responsibility if you can't do it yourself. Although I say that to clients, and that's the purpose of it, they're actually normally drafted to be used short of proving your medical incapacity, because there's going to be a time frame that you may not be capable, but you haven't actually been deemed incompetent, and that's a medical diagnosis. So there's this gray area that, we've all known people who we think probably should not be paying the bills and driving the car, but they aren't technically incapacitated in the opinion of a doctor. So that's part of that function of the power of attorney, is to allow, not necessarily deprive you of your ability to do things, but to allow you to add to your team of options of who can help you manage those assets and take over if necessary.
Right. Okay. And they can either be what we call springing, or they can be
Right.
in existence the moment you write
Durable.
them or sign them, I
Yep.
should say, execute them, right?
Right.
Okay. And they're good for how long?
Well, they're good until you technically, they're good until you either revoke it, sign a new one, or you die. And we say technically because you're still at the whim of any third party to whom it is presented, unfortunately, to say, oh, that's too old, we don't like it. So ideally, you should periodically update it. If you do become incapacitated, your attorney has the ability to say it was your last known wishes and kind of get that time clock moving again. But you should take on some responsibility to periodically, every 8 to 10 years, update it regardless.
Okay. And one other thing I wanted to cover is healthcare proxies.
Yep.
Something I think, did right in Massachusetts, and some other states have as well. Tell us what it is.
It's your ability to name someone to make the medical decisions if you can't. So that power of attorney was my financial decisions if I can't make them. The healthcare proxies, the other side of the hand, it's the medical decision making. That one, you do have to appoint people in hierarchy, who's going to be first, who's going to be second, and you can't cover any of that gray area. So only if you're incapacitated will that person be empowered to act. But they're going to make the soup to nuts decisions, the hangnails all the way up to the end of life. So it should be someone you think will do what you want, will have the wherewithal to be able to do it, not just who cries every time
That's the
the
important
cat gets
thing.
upset.
That really
right?
is the important thing.
It is.
Right. Yeah.
Because even though it might be the oldest child, the only daughter, really try to assess their capacity to handle the medical community and advocate for you, because that's not an easy job.
Yep, for sure. And the healthcare proxy as opposed to the living will?
The living will is really just an expression of what you want your end-of-life wishes to be, as opposed to naming someone in it. And it's not technically binding in Massachusetts. It's a great idea to communicate your wishes, but you still have to make sure that agent under your healthcare proxy knows what you want and will do it. Because if they say no to your pulling the plug game plan, it's not going to happen.
Right, right. Homestead declaration.
Homestead.
And we are under a new homestead declaration as of when?
Okay.
2012?
11.
11,
You're right. Yep.
Okay. And so there are a few changes, and changes take place almost every year on them.
Yes.
Protection-wise,
The automatic exemption, if you do nothing, you innocently go through your days, is $125,000. But if you want to realize the full potential exemption of $500,000, you have to file a piece of paper with the probate court. It says, I declare this is my primary residence, and you pay the requisite nominal fee.
With the registry of
With the
deeds.
registry of deeds,
Right,
and they will take it, they will record it. It's sort of simple and very fact-based, but the impact of it is it protects the equity in your home. If someone tries to sue you, you're in an accident, whatever the situation is, that equity is preserved because it's your primary residence, and we recognize you need somewhere to live.
Primary residence, very important. Can't
Yes.
do it on the second home. Can't do it on
Correct.
the third home.
Can't do it on the money you gave to your kids to buy their home. It has to be where you live.
Right, exactly. Okay, we're getting close to the end here, and I
Okay.
just want to make sure that we cover the important aspects of this. The equity that's protected, there are some exceptions to that, taxes being one of them.
Yeah. Nursing homes being the other.
Intentional acts being another one.
Yep.
If you go and break somebody's nose and he sues you for $1 million,
Right.
you're not going to be protected
And
by
say,
that.
hey, I have a homestead, too bad. Yep.
Yeah, too bad. Wrong. So there are some exceptions to that. You should
Right.
know what they are. But everyone should consider recording that piece of paper
Yes.
because it's the best insurance policy they will
Absolutely.
ever have.
And it's cheap money.
It really is. Yeah, $35.
Yep.
$35
Right.
fee. Right.
Right. But I get a lot of, does it protect you from the nursing home? It does not protect your house from the nursing home.
No,
So
that's another.
that's another important exception.
Yep. Okay, Nancy, I want to thank you for coming on. Again, Nancy's in Harvard. Always happy to answer
on
your
down.
questions. Give her a call. Send her a note. Send her an email. Do what you got to do. And she's always available, and appreciate you
Happy
coming
to.
on again.
Thank you.
Okay. And I want to thank all of you out there for watching, and hope that we'll see you again next time.